Hello everyone. Welcome back to our channel, US Immigration Daily News. We hope you're doing great. Well, in today's video we will be talking about Supreme Court finds in favor of Biden's ICE deportation green card backlog bill and US visa interview waiver. So to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe and don't forget to push the notification bell for our upcoming episode. So without any further delay, let's jump into the video. The U.S. Supreme Court ruled that both Texas and Louisiana do not possess the necessary standing to challenge President Biden's efforts in prioritizing national security threats and other criteria for immigration arrests and deportation guidelines.
This is an 8-1 decision on U.S. v. Texas, which was a Republican challenge to President Biden's immigration enforcement priorities. And I want to bring in NBC's Julia Ainsley, who's outside the Supreme Court. Julia, what do you know about this decision?
Hi, Anna. So we could still be getting more decisions in moments, but right now a decision that came out is in U.S. versus Texas, where 8 out of the 9 justices said that the states here that challenged the Biden administration's immigration policy lacked standing. They sided with the Biden administration 8-1, saying that the states did not have standing to sue the Biden administration over this policy.
The justices, in an 8-1 decision, chose not to address the question of whether the guidance from the U.S. Immigration and Customs Enforcement violated various provisions of the Immigration and Nationality Act.
The policy allowed ICE to prioritize who it deported from inside the country. It prioritized people who were threats to national security, had previous criminal past. It was their way, they said, of trying to use prosecutorial discretion because they don't have the resources to deport all 11 million or more undocumented migrants living inside the United States. It's something that the Obama administration also did. Now, it may seem surprising that you would have an 8-1 opinion in this court and that so many conservative justices sided with the Biden administration here. But there's something important to consider. If they had gone the other way, they could have set up a precedent that would have allowed or disallowed, rather, another administration coming in, say a more conservative or Republican administration, from allowing them to set up their own enforcement priorities when it comes to immigration. Immigration is a federal law, and they want to allow this presidency and future ones to be allowed to set up their own priorities when it comes to how to enforce the nation's immigration laws. There is an important piece, though, that we read in the opinion where they say, look, if the Biden administration had, for example, decided they weren't going to enforce any of these laws, then the states might have standing to come forward and say they would be unduly harmed by these policies. But they think this policy, as it stands, doesn't affect the states in any ways that would allow them to have standing in this case. So 8-1 opinion, They are allowing this administration to go forward with the policy.
Now, let's talk about green card backlog. Bill, a guide to proposed green card reform. What are the implications for highly skilled foreign workers? Among the many problems plaguing the current American immigration system is the imposition of limits on green cards for highly skilled professionals depending on their country of origin. These limits favor immigrants from less populated countries, giving them priority so that they face low wait times for permanent residence at the expense of equally skilled workers from countries with high immigration rates like India, China, Mexico, and the Philippines. Such policies raise significant ethical issues as they depend on the arbitrary metric of nationality for determining the worthiness of one skilled worker over another rather than a merit-based standard. Fortunately, legislation with bipartisan support is being introduced in both the United States Senate and House of Representatives to reform this outdated immigration policy. The issue with current green card policy. According to the standards of current U.S. immigration law, a person's country of origin is a major determining factor in the length of their wait time for an employment-based immigration visa, colloquially known as a green card. Possession of a green card allows a person to legally live in and work permanently in the United States and constitutes the first step for an immigrant seeking U.S. citizenship. The current policy means that a worker with less experience or education from a country with a lower population and thus less applications for permanent residency has a better chance of receiving a green card quickly than a worker of equal or greater skill from a country with a higher population. The impact of green card policy on U.S. economic viability. These restrictions ultimately serve to harm the effectiveness of the United States in recruiting highly skilled international workers. Policies like the per-country limit, unemployment-based immigration perpetuate the idea that obtaining residence in the U.S. and hence contributing to the long-term success of the U.S. economy is more trouble than it is worth. This negative perception encourages valuable workers to consider other countries for relocation. The U.S. economy suffers from this loss of gifted workers on several levels. First, the lack of incentive means that emerging businesses and their significant fiscal resources are drawn away from the U.S. Second, U.S. companies faced with a dwindling pool of skilled workers will be forced to move resources abroad in order to remain competitive in recruitment, the proposed legislative solution. Luckily, there is legislation in work to alleviate the effect of these oppressive policies on skilled immigrants whose only detractor in the eyes of the U.S. immigration system is their birthplace. On February 7, 2019, Republican Senator Mike Lee and Democratic Senator and presidential hopeful Kamala Harris introduced the Fairness for High-Skilled Immigrants Act in the Senate. The bill would remove the per-country cap for employment-based green cards as well as raise the per-country limit from 7 to 15 for family-based immigrants. An equivalent bill was proposed in the House of Representatives by Congresswoman Zoe Rhee, a Democrat from California, and Congressman Ken Buck, a Republican from Colorado. It is important to note that Representatives Ellery and Buck are the chair and ranking member respectively on the House Immigration and Citizenship Subcommittee, granting them the power to bypass committee process and present the bill to House Speaker Nancy Pelosi's approval to move the bill to House Speaker Nancy Pelosi's approval to move the bill to the House floor for an official vote. Legislation of this nature has been produced several times in the past with strong bipartisan support for its premise of equalizing a playing field for highly skilled international workers, but has been stalled for years until this month's reintroduction, the potential outcome for affected immigrants as of 2019. The United States presently makes 140,000 permanent resident cards available annually to employment-based immigrants under current immigration laws. No more than 7 of these green cards are allotted to nationals of a single country. This blanket provision does not account for the fact that many countries are more populous than others and inadvertently hurts immigrants with a high level of education from countries like China or the Philippines. The recently introduced legislation would attempt to lessen the pressure on these talented immigrants and strong potential contributors to the U.S. economy by eliminating per-country quotas on work-based green cards and expanding the cap on family visas. The bill also includes provisions that address potential criticisms and protects immigrants already in queue for legal permanent resident status. There is a provision in the Fairness for High-Skilled Immigrants Act, which ensures that no one who is the beneficiary of an employment-based immigrant visa approved prior to the bill's enactment will receive their visa later than if it had not been enacted. Now we talk about how to qualify for a U.S. visa interview waiver, Dropbox 2023. The interview waiver process allows certain U.S. visa applicants to bypass an in-person interview and get through visa processing much faster than the alternative of having to wait for an in-person interview, with U.S. visitor visa interview appointment wait times at well over a year. Qualifying for an interview waiver can cut your wait times significantly. Applying through the interview waiver process allows you to make a Dropbox appointment. On the day of your Dropbox appointment, you will drop off your documents to your preferred consulate or embassy and will not be required to complete an in-person interview with a consulate officer. The U.S. Embassy in India and the U.S. Department of State have continued to work together to expand interview waiver eligibility in order to help speed up processing and visa appointment wait times. U.S. visa interview waiver eligibility. To qualify for the interview waiver for U.S. visa, you need to meet certain eligibility criteria. Requirements to qualify for a Dropbox appointment are as follows: renewing any visa in the same category. Applicants renewing any visa in the same category within 48 months of expiration are eligible for an interview waiver. Previously issued any type of visa. Your in-person interview may also be waived if you are applying for FH1H, 3H for non-blanket LMOMOPQ or academic J visas and you were previously issued any type of visa, as long as you are applying for the visa within your country of nationality or residence. U.S. visa. Interview waiver eligibility. To qualify for the interview waiver for U.S. visa, you need to meet certain eligibility criteria. Requirements to qualify for a Dropbox appointment are as follows: renewing any visa in the same category. Applicants renewing any visa in the same category within 48 months of expiration are eligible for an interview waiver previously issued any type of visa. Your in-person interview may also be waived if you are applying for FH1H 3H for non-blanket LMOPU MOEPQ or academic J visas and you were previously issued any type of visa as long as you are applying for the visa within your country of nationality or residence. How to book a Dropbox appointment to determine whether or not you are eligible for a Dropbox appointment. First, visit the U.S. Travel Docs website and fill out your information accordingly. If you are notified that you are eligible for interview waiver, then you will schedule an appointment for document drop-off. How long will it take to get your passport after document drop-off? If you apply through the interview waiver process and submit your documents via Dropbox, you should allow up to 3 weeks from when your passport was accepted at the VAC Visa Application Center until your passport is either delivered or you are notified that it is ready for pickup. Can minors qualify for interview waiver? Yes. Certain minor children can qualify for a U.S. visa interview waiver. However, they must meet the following criteria: be under the age of 14 years old or have been fingerprinted by a consular officer when they were previously issued a visa. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next episode. Till then, take care.